If you have been watching individual decisions, individual ATF rule changes, and individual state laws over the past 7 months and trying to understand what it all means and where it is heading, this video is what you have been waiting for. Everything that happened between November 2025 and May 2026 in the world of gun ownership, privacy rights, and the firearms economy is not a collection of isolated events. It is a single structural conflict playing out simultaneously on multiple legal, regulatory, and market fronts, and once you see the structure if you watch by end of this video, the individual pieces snap into focus in ways that change how you think about what is coming next and what you need to do about it. Subscribe now because understanding the comprehensive architecture of this 7-month period, the legal asymmetry, the privacy erosion, and the supply economics, is the difference between being reactive to every new headline and being positioned to understand, anticipate, and protect yourself in the environment now being permanently built around gun ownership in America. 3 interlocking systems drove everything between November 2025 and May 2026. First, a structural asymmetry between federal liberalization and state resistance, creating a constitutional collision course, requiring the Supreme Court to eventually define the absolute limits of both federal supremacy and state police power. Second, a systematic erosion of privacy rights protecting gun owners in their homes, vehicles, and institutional settings. Third, supply chain and economic pressure operating independently of legal battles but producing its own form of gun control through the market. One no court can enjoin and no ruling can reverse. Let me walk through each framework in depth and then tell you what the convergence of all 3 means for the next 12 months. Number 1, the legal and regulatory asymmetry. The federal liberalization wave. The ATF's 34-item regulatory reform package, progressing through implementation from late 2025 into 2026, represents the most sweeping administrative dismantling of firearms regulation in the agency's history, addressing pistol brace classifications, solvent trap determinations, frame and receiver redefinitions, suppressor streamlining, and the framework of what constitutes a firearm for regulatory purposes. At the Supreme Court level, the same period produced decisions eliminating permit systems, striking down assault weapon bans and magazine restrictions in 19 states, confirming constitutional carry, extending Second Amendment protection to vehicle carry, and establishing legal standards for striking down state permit replacement schemes. The federal direction is unmistakable: liberalization, deregulation, and an expanding zone of constitutionally protected activity that government cannot reach. The state resistance strategy. What California, New York, New Jersey, Illinois, Virginia, Colorado, Maine, and Massachusetts figured out is that direct constitutional confrontation with the Supreme Court is unwinnable. They lost on permits, assault weapon bans, magazine restrictions, and registration. But losing those battles did not end the war. It redirected it into procedural suffocation, mandatory training of 16 to 40 hours, certification costs of $300 to $800, application fees of $200 to $500, processing delays of 3 to 18 months, sensitive place designations covering 60 to 90% of publicly accessible spaces, social media reviews, psychological evaluations, liability insurance mandates of $500 to $1,000 annually. None is an outright ban. All of them combined make legal gun ownership practically inaccessible for working-class citizens while remaining manageable for the wealthy. Where the asymmetry leads. The constitutional collision between federal supremacy and state police power is already producing the litigation that will define American gun law for the next generation. Anderson versus Bonta established a 4-part test for unconstitutional permit replacement schemes, but that test applies to administrative prior approval systems, not after-the-fact training mandates, liability insurance requirements, or sensitive place saturation. Those questions are coming. The Supreme Court will need to decide within 2 to 4 years whether a state can effectively nullify Second Amendment rights through procedural accumulation, even when no single procedure is itself an outright ban. Number 2, the privacy erosion running parallel to the gun rights expansion. The warrantless entry expansion, Case versus Montana, January 14, 2026, confirmed police can enter your home without a warrant when third-party reports and observable circumstances create an objectively reasonable basis to believe an occupant needs emergency aid. The visible empty gun holster in William Case's window was part of that justification. Every gun owner displaying firearms near windows visible from outside now lives under a regime in which the combination of a hostile third-party call ex-partner, estranged family member, neighbor with a grievance, and the visible presence of legally owned firearms can constitute the basis for warrantless police entry in tactical posture appropriate to an armed and potentially dangerous occupant. The school interrogation window. Halosh versus Cass City. Public schools, December 18, 2025, confirmed that in the post-Oxford climate, a classmate's unverified report of threatening statements is sufficient for school officials and police to search a student, interrogate them without Miranda warnings, and use everything the student says in subsequent criminal proceedings. For gun owners with children, a classmate's mischaracterization of your child's words can produce a warrantless search and an un-Mirandized interrogation whose results are usable against them. The traffic stop protection that cuts both ways. Miller versus Pennsylvania, May 28, 2026, unanimously held that lawful firearm possession cannot justify a Fourth Amendment search or extend a traffic stop. But Miller's protection is incomplete. It applies to lawful possession. Any ambiguity about carry status, permit validity in a state that requires one, vehicle storage requirements that differ between transit states, jurisdictional questions about magazine legality, erodes the Miller protection at exactly the edges where it is needed most. The structural theme, the pattern is consistent. The law provides protection in core cases while leaving margins open. You cannot be searched solely for legal carry, but your visible holster during a welfare check can justify warrantless entry. Your child cannot be randomly searched, but a classmate's unverified report can trigger it. The rights exist. The exceptions are multiplying. Number 3, the supply chain and economic pressure that no court can fix. The Iran campaign effect on civilian supply. The United States military campaign beginning in early May 2026 consumed military munitions at a rate that directly affected civilian ammunition supply through Defense Production Act priority orders. The same production facilities that manufacture 5.56 9mm and .308 ammunition for civilian consumers were operating under federal priority orders for military production. The result? 40 to 70% allocation reductions at retail, 20 to 40% price increases, and the beginning of regional shortages in the calibers most commonly used for home defense and range training. The tariff multiplier. Trump administration tariffs of 25 to 45% on imported ammunition and components, announced March 2026, eliminated 30 to 40% of civilian ammunition supply from Czech Republic, Serbian, South Korean, and other foreign manufacturers who had been a primary source of affordable practice ammunition for American civilian shooters. The tariffs and the military consumption are independent pressures. Together, they are removing more than half of normal civilian supply at a moment when demand is elevated by the legal expansion of gun rights, creating new gun owners. The market-based gun control nobody is talking about. Here is the structural insight that synthesizes everything. The federal government is liberalizing legal access to firearms. The Supreme Court is expanding constitutional protections for gun owners. And simultaneously, economic and geopolitical forces are making it increasingly difficult and expensive to purchase ammunition, to practice, and to keep firearms in operating condition. A right you cannot exercise because ammunition costs $1.50 per round, and you can only afford 20 rounds every few months is not meaningfully different from a right restricted by a permit system. The state-resistant strategy of procedural suffocation has a market-based complement that operates automatically, without legislation and without judicial review. This is not a conspiracy. It is a structural outcome of the intersection of military priority production, trade policy, and supply chain economics. But it is producing the same result, a Second Amendment that is expansively protected in law and increasingly inaccessible in practice for working-class Americans. What the convergence means, and what you need to do. On the legal front, the Supreme Court has established the framework. The fights now are in the circuit courts, in the district courts, and in state legislatures that are testing the outer boundaries of what procedural accumulation can survive constitutional scrutiny. The next 12 months will produce rulings on after-the-fact training mandates, liability insurance requirements, and sensitive place saturation strategies. Watch these cases. The decisions will determine whether the legal victories of the past 7 months produce real-world change or remain paper rights in the most restrictive states. On the privacy front, manage your exterior firearm visibility. Be accessible during welfare checks. Your non-response legally contributes to warrantless entry justification under Case v. Montana. Know the Miller v. Pennsylvania script for traffic stops. Educate your children about their limited Fourth Amendment rights in school settings. These are not abstract concerns. They are operational facts of life for gun owners in the legal environment established between November 2025 and May 2026. On the supply front, the military campaign consuming munitions is ongoing, and the production priority orders are likely to remain in effect through 2026. The tariffs are in place and unlikely to be reversed quickly. The civilian ammunition shortage is structural, not temporary. Prioritize purchasing what you need for home defense first. Caliber diversification, owning firearms in calibers less directly affected by military consumption and tariff impacts, is worth considering. Reloading is worth learning if you are a serious shooter. Join the organizations that are fighting the legal battles. Firearms Policy Coalition, Second Amendment Foundation, Gun Owners of America. These organizations are litigating the circuit court fights over procedural suffocation, the district court fights over ATF reform challenges, and the class action suits arising from red flag law overturning. They are also the early warning system when new state schemes emerge that require immediate legal challenge. Bottom line on the November 2025 to May 2026 period. The legal architecture has shifted decisively in gun owners' favor at the constitutional level. Permit systems gone, assault weapon bans struck, magazine restrictions eliminated, vehicle carry protected, traffic stop searches for legal firearms prohibited. The Second Amendment is at its strongest doctrinal position in modern history. Simultaneously, the state resistance has shifted entirely to procedural suffocation. Training mandates, fees, delays, sensitive places, insurance requirements, that is being litigated but has not yet been fully resolved. The privacy framework is eroding through emergency aid exceptions, school search expansions, and welfare check weaponization that creates specific vulnerabilities for gun owners. The ammunition supply is under structural pressure that court decisions cannot address. The convergence of these three dynamics produces the essential condition of 2026 gun ownership in America: maximum legal protection and maximum practical pressure coexisting in the same system. Understanding both sides of that equation is not optional. It is how you protect yourself. Subscribe because the next 12 months will resolve some of these questions at the circuit court level and create new ones at the Supreme Court level, and every development in that process directly affects your rights, your safety, and your supply.